This courtroom showdown is one you won't forget. Today we're watching the case of Mr. Blay, a defendant facing multiple felony charges, probation violations, and even drug possession. The stakes couldn't be higher. Years of freedom hang in the balance, and the judge is about to decide his fate. But here's the twist. Instead of a single mistake, this defendant is accused of breaking probation multiple times, testing positive for drugs, and even committing assault while already on deferred probation. Will the judge show mercy or drop the hammer with a harsh sentence? Stick around, because this hearing takes some shocking turns.
It's my understanding I had previously prepared for a hearing on those new offenses. At that time, the case was reset, so I did not have the officer subpoenaed for today. I can certainly get them if the court would like to hear from those. It's my understanding that he now intends to enter pleas of true to those new offenses. When we were here last, we had semi-made the suggestion of ISF/SafeP, and my understanding that he's already gone to ISF, just from the reaction that the court kind of gave us to that, and in my extensive conversation with Ms. Johnson, we have taken that offer off the table and made an offer of 5 years in all 3 of the felony cases for a revocation, which would then make him a repeat offender if he's back in front of you.
Okay. And that's your understanding and your agreement as well, Mr. Burbank?
Yes, Your Honor, and we prepared paperwork and 3 indicated 2 MTRPs and new possession.
I only see 2. Is there another set of paperwork? I've got the 2 MTRPs. I don't see the new case. So we already went through those motions. I guess I just need to go through them again because there's going to be a change of plea.
3, 4, and 6, Your Honor.
Let me, if you'll print the second one, I'll print the first one. Let me get those pulled up real quick just to make it easier for me to go through. And we can print the ones that were already modified. That way I can make notations on that.
And Judge, just again, I know I had let you know last time, I'm not meaning to interrupt you.
Go ahead,
While you're
just
reading,
print.
obviously the concern of the original underlying offenses back in.
Okay. Okay, I'm getting there. Okay, so
Would it be better if I made an oral motion to withdraw previous?
nope, I'm just gonna go back and I'm gonna just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
He will in
The motions.
all cases.
Okay. Mr. Byerly, in cause number 18-28800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct?
Correct.
And then in cause number 18-29063, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, also for violation of a protective order, a 3rd-degree felony, and that was also a 10-year deferred probation. Is that also correct? And so it alleges that you violated your probation, and y'all are going to go.
1, 2, 3, 4, and 6.
Okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5.
Oh,
6 is that he possessed it. But 5 is committed the offense. So that would make
I'm
sense.
sorry, they're different numbers in each one. One
Oh,
is 6
great.
and one is 5.
I love that when that happens.
If you want to amend, Judge, we'll go.
No, it's okay. I have to do, it's the numbers are the numbers. Okay. Count one in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count two alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
Two. And then count three alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well. Count four in each case alleges that you failed to abstain from the use of any and all intoxicating substances and that you tested positive for alcohol April 15th of 2025. Is that true or not true?
True.
And that's also in both cases. Count five in cause number 18-29063 and count six in cause number 18-28800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. And is that true or not true?
True.
Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true. In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal? State tenders number 1 in each of those cases. It's admitted in each of those cases. Is there any evidence that Mr. Byerly is not competent? All right, Mr. Byerly, in each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. And cause number 18-29063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 18-28800, find counts 1, 2, 3, 4, and 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Bless you.
Thank you.
Give me just a second now. Those two, and did I print 2?
Yes, ma'am.
Okay, now let's go to okay, now, Mr. Byerly, in cause number 25, DCCR 0943, You're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case. It's admitted. Mr. Byerly, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I have handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. Thank y'all. Thanks for your patience for me getting through that. Okay.
I'll take the front. Okay.
Okay.
And there it is. The gavel comes down and the sentence is official. Let's break this down step by step because this case is a perfect example of how probation works and how quickly it can all unravel. From the start, Mr. Blay was on thin ice. Back in 2019, he received deferred probation for violating a protective order, not once, but in 2 separate felony cases. Deferred probation is essentially a second chance. If you follow the rules, you avoid a conviction on your record. But if you violate the terms, that deferred status is gone, and suddenly you're facing the full weight of the law. That's exactly what happened here. Fast forward to 2025, and the violations start stacking up. The judge lists them one by one: assault, positive drug tests for opiates, skipping mandatory programs, alcohol use while on probation, and finally, the big one, possession of a controlled substance. Each of these is a strike, but together, they paint a picture the court can't ignore. This isn't a single lapse in judgment. It's a pattern. And in probation cases, patterns are everything. Notice how the defense and prosecution worked this out. Instead of dragging officers in to testify and going through a full contested hearing, the defense had Mr. Blay plead true to the violations. That's basically admitting, yes, I broke the terms of probation. Why do that? Because it's often part of a plea deal. In this case, the deal was 5 years in prison for each of the felony cases, plus the new drug charge, all running concurrently. Concurrent sentences are important. It means the clock runs at the same time, so instead of 15 years stacked up back to back, he serves just 5. It's still prison time, but it's far better than what it could have been. The judge makes something else very clear. Because these pleas were part of an agreement, Mr. Blay waives his right to appeal. That's standard in negotiated pleas. And then comes another hammer blow: the firearm prohibition. Under Texas law, anyone convicted of a felony loses the right to own or possess a firearm. That includes not just guns, but certain other weapons classified under the statute. The judge carefully explains this to avoid any future confusion. Now here's where I want you to think critically. Was 5 years fair? On one hand, we're looking at repeated violations, drug use, and a new felony while already on probation. Many judges might have gone higher. On the other hand, the concurrent sentencing keeps it from being completely life-ruining, giving Mr. Blay a chance to serve his time, get credit for days already in custody, and eventually return to society. Some people might call that mercy. Others might see it as too lenient. What do you think? Should repeat probation violators be given shorter concurrent sentences, or should each violation stack the time higher? One more takeaway. Probation is not a free pass. It's a strict contract with the court. Every missed program, every failed drug test, every fight or assault, it all adds up. And once those violations pile too high, the court has little choice but to revoke probation and send you to prison. This case is the textbook example of how second chances can quickly disappear when rules are broken.